Good afternoon, everyone. It's so good to have you all here. My name is Elisa Jones, and I'm an assistant professor at the College of Charleston, and I had the pleasure of co-organizing this program with my colleagues, Dr. Shannon Eves and Dr. Zeb Dingley. On behalf of the Department of History, we are happy to welcome you to our third annual Black History Month lecture with Dr. Tamika Nunley of Cornell University, titled Black Women's History as American History and the Demands of Justice. The lecture will be followed by a question and answer session, and we are recording the program for future use. This lecture series is a part of our department's ongoing work towards implementing its diversity and inclusion action plan, which you can find on our website. The purpose of the series is to bring leading historians and cutting-edge scholarship in the field of Black history to the College of Charleston and the surrounding community, and Dr. Nunley certainly meets that criteria. We thank her for accepting our invitation and for generously giving her time this morning to participate in a workshop with students from majors across the college about her important research. It really was an uplifting experience for me as well. The Department of History also thanks our many generous co-sponsors that helped make this programming possible: the African American Studies Program, the Avery Center for African American History and Culture, the Carolina Low Country and Atlantic World Program, the Center for Public Choice and Market Process, the Center for the Study of Slavery in Charleston, the Department of Political Science, the Office of Institutional Diversity, and the Women's and Gender Studies Program. Thank you all. Finally, we would like to offer a word of thanks to our own President Hsu for being here this afternoon, and I believe he would now like to offer a welcome on behalf of the college. Thank you.
Thank you, Dr. Jones. It's such an honor to be here to help welcome everyone to our third annual Black History Month lecture. And Dr. Eves just reminded me that I actually helped you open up the first one 2 years ago, and that was during COVID, and I helped welcome everyone online through Zoom. So today's speaker, Dr. Tamika Nunley of Cornell University, is an award-winning scholar in the area of race, gender, slavery, legal history, and 19th century America. Her scholarship brings to life the people who, did I change the? Sorry. Her scholarship brings to life the people who experienced one of the darkest chapters in this country's history. While the subject of slavery is certainly bleak, Dr. Nunley's work reminds us that these were real people, living very real lives, trying to make do the best way they could. That means they were people of intellect with rich imaginations and feelings of hope. And it is through their hope that they strove for liberty, self-respect, and power, even if the law of the land worked against their efforts. While Dr. Nunley's work focuses on things more than 100 years old, or 100 years ago, oppression is not something relegated to the past. Oppression in many different forms is still part of human experience today. But it is through historical research done by scholars like Dr. Nunley and many of our faculty members here at the College of Charleston that we are reminded today that people are strong and that they can persevere. Meaning we too are people of strength and resilience. Again, please help me welcome Dr. Nunley to the College of Charleston with a big round of applause. And once again, I welcome all of you to our third annual conference. With that, let me turn things over to Professor Shannon Eves, Dr. Eves. And also, I want to apologize to particularly Dr. Nunley that I have to run. I have to drive to Columbia right away. So sorry, I will miss your speech.
Thank you so much, President Hsu. We appreciate you being here to welcome everyone, and we look forward to having you back at a future lecture.
I'll be here the fourth one.
Okay. Thank you. Good evening, everyone. My name is Dr. Shannon Eves, and I'm the professor of African American history in the Department of History here at the College of Charleston. And it brings me great pleasure to introduce a fellow scholar of African American women, slavery, and who is more than a professional colleague, but also someone who brings me very great inspiration as I aim to do the very thing that she has done, which is to create beautiful scholarship. And so I'm so pleased to have this opportunity to tell you more about her and prepare you for what you're about to hear. Dr. Tamika Nunley is an associate professor of history at Cornell University, where she teaches courses and conducts research focused on the history of slavery, African American women's and gender history, the early republic, and the American Civil War. Her first book, At the Threshold of Liberty, Women, Slavery, and Shifting Identities in Washington, D.C., won the 2021 Letitia Woods Brown Book Prize for Best Book in African American Women's History, and the 2021 Polly Murray Book Prize for Best Book in Black Intellectual History. She is currently finishing a second book, The Demands of Justice: Enslaved Women, Capital Crime, and Clemency in Early Virginia, 1662 to 1665, that examines clemency in legal cases that involve enslaved women accused of capital crime in early Virginia. Her work has been supported by the Andrew Mellon and Woodrow Wilson Foundation, as well as the American Association of University Women and the Bright Institute Fellowship. So please join me in welcoming Dr. Tamika Nunley.
All right, excuse me. Coming from Ithaca, where we have freezing weather, to coming to 73 degrees has my sinuses doing jumping jacks. So that was me coughing and hacking in the front. I want to thank you all for being here. I'm just so excited to see all of your faces, especially the students. I've had such a marvelous time meeting each of you and engaging with you. And so just thank you for taking the time to be here today and listen to some of this work. I also want to thank the hosts, the committee, for the invitation to come speak here, all of the sponsors of this event, and thank you, the College of Charleston, just for the warm welcome that I've received. It's been such a pleasure being here. And I didn't need any convincing to come here because you all have 70-degree weather and delicious food. So, and so thank you all so much. I'm going to read a presentation about my second book, which comes out next month. It's called The Demands of Justice, and I wrote it during the pandemic, and it's a book where the stories are really challenging to confront, but I think that it'll be really rich to hear your questions, to hear how you're thinking about some of the stories that you will hear. These stories are hard stories, these are hard histories, but it seems like with the work that you all are doing here at the College of Charleston and also some of the organizations that have sponsored this event is also engaged in that work in a really meaningful way, and so I'm really glad to present this work in front of you. August in Virginia left a sweltering haze over its victims as the heat and humidity reached peak levels at the close of summer. Peggy, an enslaved woman in New Kent County, found herself battling the heat while laboring for John Francis. Something about this year, this month, felt different. Francis made a habit of terrorizing Peggy, and by the end of the summer, his violence proved particularly acute. Over the years, however, she retained the wisdom of her mother, a woman forced to bear children with John Francis, their enslaver, who warned her of his plans for Peggy. Could she anticipate the events that followed? This story is not a new one. Here I look to murder to show that the insurgent behavior of enslaved women and their comrades preceded the violent and legal end of chattel slavery. These stories remind us that by the end of the Civil War, enslaved people set in motion a series of rejoinders reminiscent of the battles they fought in the decades leading up to the conflict. Vincent Brown argued that the slave trade catalyzed ongoing diasporic warfare, and although his work attends to the 18th century, the same might hold true in the antebellum South. Brown asserts that, quote, "This is not a war in the conventional sense, however, involving disciplined armies directed by their rulers of states. Rather, it is the simmering violence inherent in mastery, by its nature of forceful assault and the slave's countervailing resentment of slaveholders' fraud, rapine, and cruelty," end quote. Historian Stephanie Camps reminds us in Closer to Freedom that enslaved women engaged in everyday acts of resistance that preceded wartime actions waged against their former owners. And in Virginia, this fact holds true. Thavolia Glimpf offers that slave resistance, the burning of planter homes, murders, conspiracies, and flight, confirmed how much enslaved people knew and understood about the conflict and put their experience as knowledge brokers to new use, end quote. Manifestations of enslaved women's act of urgency revealed their anti-slavery and liberation politics. The Civil War allowed for them to act on stores of knowledge, memory, and strategies of resistance passed down and developed over time in geography. These tactics were not novel. Indeed, they appeared repeatedly throughout the decades leading up to the war. The story of Peggy and the enslaved women, men, and children that follow reveal the ways that they became the knowledge brokers that Glimpf speaks of. John Francis taunted Peggy, his daughter, with numerous threats of assaulting her. In one incident, he vowed to have two enslaved men, Jesse and Patrick, hold her down as he acted out his sexual desires despite her clear rejection of him. Testimony later revealed that he regularly kept Peggy chained to a block and locked up in a house on the property. In another instance, John Francis chained her to a block and hurled violent threats and promises to sell her further south, which he, like countless others taking revenge on enslaved women and girls, believed subjected her to the same fate he prepared for her on his estate. Perhaps he hoped that she would acquiesce with the prospect of remaining near the people and place she knew well. But what comfort might she find in either place in the face of sexual terror? Peggy's half-sister would later testify that, "I know the deceased wanted to cohabit with Peggy, to which she objected, and that was the cause of the difference between them. I know the deceased threatened Peggy to beat her almost to death and to send her off if she did not yield to his wishes. Peggy decided on a different fate." On the evening of August 22nd, 1830, Peggy enlisted the help of Patrick, Frankie, and Caroline to murder John Francis and set his home ablaze. Who were Patrick, Frankie, and Caroline in Peggy's life? Witnesses explained that Patrick suffered from a mental disability and could hardly be seen as a culpable participant in the incident. People on the plantation, however, knew Patrick from his strength, a physical advantage that John Francis called upon when Peggy refused his advances. Frankie and Caroline joined the effort, but on what basis? Perhaps they were motivated by their kinship with Peggy, or they possessed their own set of grievances that motivated their actions. Collective and sporadic action might be the result of numerous injuries incurred by the enslaved, along with mutual ties that pull others toward a particular conflict. In this instance, they all seem to be in agreement that something must be done. Peggy and Patrick approached the entrance to the Francis home with a sharpened axe and a wooden stick. According to Patrick, Peggy held the axe. Witnesses heard knocking, thumping, and wailing within the house. Those were the sounds of Peggy and Patrick beating John Francis to his death, and upon the final blows to his body, witnesses heard him cry out, "O Lord, have mercy," until he fell silent. Peggy, Patrick, and Caroline left his body and proceeded to gather bales of hay, which they used to stuff large quilts. The three of them approached the house with the stuffed quilts, tossed them inside, and lit them on fire. The flames quickly engulfed the house, which contained John Francis's body, lying limp against the wall. When a neighbor noticed the glow coming from the house, he rushed over and took sight of the ravenous fire. The house collapsed, and a charred body appeared at the corner of what remained of the dwelling. Not long after the defendants arrived in the court on September 10, 1830, locals began to assemble a petition. After hearing the testimony of witnesses, the court dismissed charges against Caroline, but the court found Peggy, Patrick, and Frankie guilty. Perhaps the affair came as no surprise, since the sexual appetite John Francis possessed appeared as general knowledge even as it offended local sensibilities. One white witness testified that, quote, "It was currently reported in the neighborhood that the deceased was the father of Peggy and that he wished to have illicit intercourse with her," end quote. Several witnesses confirmed that they knew John Francis to be Peggy's father. This history of his violent exploitation of enslaved women and incestuous behavior became an unsettling fact for the residents of New Kent. 100 residents of New Kent signed a petition to request executive clemency for the enslaved people involved in the incident. The petition included a statement that, quote, "There are circumstances attending the case of the poor ignorant slaves, although not sufficient to justify the act for which they are condemned, yet in the opinion of the undersigners should mitigate the punishment," end quote. In the petition, the signers expressed knowledge of circumstances that did not appear sufficient to justify the act, yet the punishment of sale had, quote, "the same effect on society as the punishment by death," end quote. The petitioners revealed an important aspect of the legal history of clemency in cases involving enslaved women, that the sale of criminalized enslaved people possessed the, quote, "same effect on society as the punishment by death," end quote. In Virginia, the circulation of money, bodies, deeds, and receipts for the value of enslaved people remained a constant feature of sentencing outcomes. These practices shaped the meanings of justice for those removed from slavery's chains, but for the enslaved, the possibilities for justice demanded new interpretations and methodologies for meting out these claims. Peggy, her mother, and perhaps a number of women suffered on the Francis homestead under laws that permitted his violent use of power. Locals used petitions to express their disapproval of such behavior, and yet they knew of his antics, and like most Southerners, displayed their silent tolerance and indifference prior to the incident. What changed? As many locals watched the Francis home go up in flames, Peggy's actions sent a ripple through New Kent that brought his behavior to the surface. John Francis and his reputation threatened the integrity of the overall reputation of the local community. Through the petition, locals sent a signal to Richmond that Francis did not represent the values of county residents. A judge, the sheriff, and constables all signed the petition in favor of a commuted sentence. But as they remind us, the sentence was less about favorable circumstances for the enslaved, since commutation produced the quote-unquote same effect, and more about a consensus that made John Francis an outsider. The governor approved a commuted sentence for Peggy, Patrick, and Frankie. Virginia's brand of justice did not protect Peggy from John Francis, and she resolved to do whatever remained in her power to end the torment. Peggy's fight might be understood as a matter of insurgency or the posture of revolt, even in the absence of an immediately transformative revolution of society. Patrick, Frankie, and Caroline collectively joined the effort, even as they understood the grave consequences that awaited them. They were compelled by values and ideas that transcended the legal and social logic of the slave South, and they weren't alone. Here I examine the lives of enslaved women accused of capital crimes to understand how slavery and its corresponding laws and social customs worked to criminalize them and limit their access to legal justice. The conditions of slavery that legislators codified in law meant that the contours of the criminal justice system posed limits to the manner in which enslaved women and girls might seek redress through the courts. If they were raped, beat, or maimed by white Virginians, they could not avail themselves to justice in the courts. Justices understood the cruelties that made slavery a system notorious for violence. Ever aware of the contradictions between the noble principles of liberty that the United States championed and the realities of lifelong bondage that fueled the labor demands of the nation, lawmakers sought to create a legal system that both empowered the authority of slaveholders and carved out the possibility for a more benevolent feature of the law, clemency. Historian Walter Johnson explains that this peculiar mixture of ostensible moderation and outright threat was called paternalism. In instances where enslaved women and girls violated the law and qualified for executive clemency, the best possible outcome relegated them to a return to the conditions that drove them to such actions, or to sale to another slaveholder. The women and girls here engaged in acts of refusal, which the courts recognized as transgressive actions committed outside of the parameters of the law. Even petitions from locals who explained the brutal conditions or unusual circumstances that shaped a particular case did not rescue an enslaved woman from the gallows or the domestic slave trade. So then, what is justice under such a system? This is the question I explore with a focus on enslaved women and girls in the 19th century who found themselves in conflict with white Southerners that began outside of the courts. It is in the intimate spaces of rooms, kitchens, farms, cabins, and the nooks and crannies of estates that dotted the diverse landscapes of the Commonwealth that enslaved women and girls made decisions, for reasons of their own, that changed their lives forever. Denied a trial by a jury of peers, when they arrived to the courts and stood before the local justices, people who barely knew them determined their guilt. Before they arrived at court, they were people who loved, worked, cried, shared stories with kin, and discovered strategies of survival. But the society they lived in also viewed them as legal property, and the law maintained the expectation that they remain subject to the authority of the people who enslaved them, regardless of the cruelty that they might experience. This is not a history that romanticizes the actions of enslaved women and girls, and additionally, I will not take up space to discuss the merits and nuances of the early legal system. I arrive at this work to think seriously about what these actions might mean, and what they tell us about alternative considerations of justice, not yet realized in the legal system, but manifested in the decisions of enslaved women and girls. In All That She Carried, historian Taya Miles asks, how does a person treated like chattel express and enact a human ethic? What does an individual who is deeply devalued insist upon as her set of values? Sources from the archives dress the enslaved up in numbers, figures, calculations, lists, and estimations to enact the logic of slavery. The criminalized actions and behaviors of enslaved women throw these methods off and impose their presence and ideas in ways that inspire more questions than the sources can answer. Enslaved women responded to the conditions of bondage in a number of ways that might lead them before the courts and jurists in Virginia. In these legal encounters, we not only see a system that worked to define and affirm a commitment to legal paternalism, that upheld the rule of law and made slavery viable, but decades of responses made by the countless enslaved women accused of capital offenses. These responses constituted the makings of an intellectual history of enslaved women's articulations of justice. The cases explored here begs the question of what do enslaved people do when they are deemed unworthy of justice because they are pulled into the criminal justice system for capital offenses? What if the redress they seek is not possible within the legal system as it existed in the 19th century? What if we seriously considered the battles waged by these women and girls as evidence of a legal system that is insufficient for the justice they seek? Rather than solely emphasizing the repressive elements of the criminal justice system, this study explores the relationship between slave law, gender, and resistance to consider the intellectual possibilities of justice and clemency. This is not, however, a legal history, but a history of ideas and actions deemed impalpable because of the ways that enslaved women and girls were criminalized. So let us revisit these actions with an eye toward ideas. During the Christmas holiday of 1856, Prince William County local G.A. Hutchinson stumbled upon a fire that consumed the home of George E. Green. As he approached the burning house, to his horror, he discovered what he described as the charred spine and pelvis of an adult. Hutchison proceeded to walk down the path leading from the house to the barn, where he found traces of blood smeared along the road and the slats that lined the gate. Scenes of blood, broken gates, and a split latch to the entrance gave indication that a struggle occurred prior to the fire. But the blood-stained hatchet that survived the fire also confirmed suspicions of a potential scuffle. An enslaved woman named Nellie, along with her children, Betsy, James, and her grandchildren, Elias and Ellen, were jailed and charged with the murder of their owner, George E. Green. The court identified Nellie, the grandmother, as the ringleader. In Nellie's case, ideas about Black women's deviant behavior and considerations of age guided the debate about culpability as locals scrutinized the 3 generations of enslaved people tried for the death of George E. Green. Based upon Nellie's testimony, the group confronted Green in his home when Nellie reached for an axe and struck him. Green attempted to escape, but the others pursued him with shovels, axes, and slats from the fencing. Among networks of kin based upon trust and loyalty, enslaved people shared knowledge about plots of resistance, but some also inadvertently became involved. Afterwards, Betsy, James, Elias, and Ellen tied the body up and dragged his body back to the house, where they set the dwelling on fire. When asked about her motivations for the murder, Nellie offered the following statement. "He was a hard master. He would not give us enough meat to eat. He would not allow any of us to go from home, nor give us any of the privileges which other people's servants have. He told us we should stay home during the Christmas holidays and work. We concluded to get rid of him." As scholars have shown, withholding the modicum of privileges some enslaved people received marked one of numerous grievances that inspired slave resistance. According to Nellie, Green violated what historians refer to as the paternalist ethic, described as the mutual obligations between master and slave that allowed for the quote-unquote privileges that she referred to. These privileges, however, do not suggest that Nellie or any other enslaved women were compelled by Southern paternalism. Indeed, Nellie told the Examiner that they were, quote, tired of living with him, meaning that perhaps Green made a habit of making life particularly difficult for enslaved people on his plantation, and that her resolve to continue to survive such suffering had worn thin. James stated that, quote, "he was hard upon us and we could do nothing to please him," end quote. Despite the fact that the bond people on Green's homestead described his difficult personality, the focus of local debate emphasized community perceptions of the enslaved defendants, and Nellie in particular. The court found Nellie, Betsy, James, Elias, and Ellen guilty of murder and sentenced them to death. On the morning of the execution, Nellie, Betsy, and James, the elder members of the enslaved family, died by hanging. Petitions appeared, however, on behalf of Elias and Ellen to keep them from the gallows. The court records identified Nellie as the ringleader of the group, but she meant more than that to those she called kin. She was the matriarch, the grandmother to Elias and Ellen, and the mother of Betsy and James, the glue that held the family together for generations. Betsy and James were treated as accomplices in the record, and Nellie vocalized her personal dissent, noting her exhaustion from years of serving a hard master. Locals neither offered gendered critiques of Green and his failed paternalism, or even an account of her experiences with a slave owner who lacked the even-handedness that Southerners referred to when they defended slavery as a positive good. She survived decades of enslavement, bore children, helped rear her grandchildren, all while enduring the harsh conditions of life on Green's plantation. And yet the debate placed the moral burden on Nellie. Years of devotion and survival, not to mention the reproductive profit she produced for the Green family, were reduced to descriptions of Nellie as a corrupting and evil influence. Elias and Ellen, twins around the age of 14, allegedly participated in the struggle to bring Green to his demise. Petitioners, however, were unconvinced that their participation warranted the death penalty. Their reservations explicitly probed the question of whether or not the twins willfully assisted with the homicide or fell under the pressures of their grandmother. Sinuses are acting up. The petition shows that members of the local community disagreed about the appropriateness of the death penalty in this particular case. Concerns about the age of the defendants appeared in letters sent to Governor Henry Wise, to whom petitioners appealed for pardon on behalf of the siblings. One resident, Luther Lynn, offered that, quote, "It is usual for parent slaves to exact obedience from their young children and to correct them," suggesting that they had limited, if any, say in their participation if the parents were involved. Locals who questioned the culpability of the twins simultaneously reinforced a scathing critique of enslaved mothers and grandmothers as the purveyors of violent crime. Similarly, Thomas Bales of Snow Hill, Maryland, noted that, quote, "Some who attended the trial and heard the evidence are impressed with a strong conviction that the two children might have been instigated by their seniors," end quote. To underscore the moral tone of his letter, the former Presbyterian minister cautioned the governor, saying that, quote, "Acts of mercy are the acts which guide our own exit from the world," end quote. But even the moral suasion of onlookers met with equally passionate conviction in arguments for Elias and Ellen's execution. The petitions received in the governor's office represented different ideas about race, gender, and age. J.B. Grayson, a Prince William County resident, argued that all of the convicted slaves, quote, "went most deliberately to work," and further noted that the woman, Ellen, is of large size for a woman and very well developed physically, probably as well developed as she ever would be, end quote. Grayson shifted the conversation to direct attention to the development of Ellen's body as an indicator of maturity and to probe her capacity for culpability. Ellen's perceived physical and even sexual maturity coincided with typical assumptions that shaped slaveholder exploitation of the sexual and reproductive aspects of pubescent girls' bodies. This racial and gendered calculation of the bodies of enslaved children rendered the innocence and adolescence attributed to white children beyond their reach as they faced charges and forms of sentencing assigned to adults. Moreover, Elias was smaller in stature, but Grayson asserted that he was, quote, "admitted by all to be the most intelligent of the set," end quote. He concluded that physical maturity and mental acuity superseded moral arguments that focused on their age. Thus, the intellectual propensity to both formulate an attitude of malice and the physical possibility to act upon those motives colored perceptions of Ellen and Elias's involvement. According to Grayson, only those who claimed residence in Prince William County offered the most reliable perspective on the matter. Writing as, quote, "a citizen in the immediate neighborhood and of this most fiendish murder," Grayson argued that petitioners in favor of transportation were primarily residents of neighboring counties and have no more right to petition your excellency in regard to this, our own county business, than I have to advise that you do not allow your overseer in Accomack to whip one of your Negroes there who disobeyed him, end quote. The decision, however, fell in favor of dissent when Governor Wise issued a statement commuting the sentences to transportation. Ellen and Elias escaped the gallows but remained in bondage without the elders who raised them, and perhaps offered daily examples of generational resistance and their own ideas about justice when they were alive. The governor declared that, quote, "the three oldest were executed, which I deem all sufficient for public justice and example," end quote. The latter part of Wise's statement reveals that these gestures held a notable degree of symbolic value. The imperative to make an example of one or few suspects appeared in earlier approaches to the punishment of slave rebellions, but this statement also offers an example of how commuted sentences infer the symbolic meanings of balance and moderation. Issued only in sporadic instances, the power and logic behind clemency, as it appears in the records, remained elusive, as every case resulted in an uncertain and yet still violent outcome. According to Wilma King, slaveholders determined that enslaved girls and boys reached adulthood at the age of 16, when they became full hands, or even younger for girls when they began menstruation. King also notes that white males were considered adults between the ages of 18 and 21. In other cases, enslaved people could be treated as adults as early as 14. These ideas offered the gendered calculus that determined the innocence or culpability of enslaved girls. A murder case in Prince William County unfolded with the same level of publicity, but ignited a very different debate about the sexual exploitation of enslaved women and the reputations of white men. In the winter of 1850, an enslaved woman named Agnes sparked rumor and debate as she appeared on trial for the murder of slaveholder Gerard Mason. Several different news accounts emerged with mixed ideas about how Mason's death occurred. The Baltimore Sun reported that one evening, Mason stumbled into his home under the influence of liquor and that he became offended with something the woman had done and threatened to kill her with his axe. The article stated that Agnes, wresting the axe from him, struck the blow that killed him. And this account of what happened seemed to suggest that Agnes acted out of self-defense rather than premeditation. Mason appeared as a master whose drinking led to his demise at the hands of an enslaved woman. Another interpretation read by locals, an article published by the Alexandria Gazette, told a more decisive story. One witness to the trial offered that beyond a rational doubt that Mr. Mason was killed in his bed, most probably while asleep, by blows inflicted with an axe by the accused. In this account, the reporter circumvented the prospect of her acting in self-defense and instead presented a case that portrayed her actions as a calculated effort to murder Mason. The degree of premeditation determined her sentence, but the reputation of Gerard Mason also shaped the possibility for the recommendation of leniency. Gerard Mason came from a family line of prominent Virginians. Conflict was not uncommon within Virginia families and institutions that boasted long and wealthy lineages. In 1829, Mason received an appointment as a trustee of the town of Occoquan in Prince William County to oversee the economic development of Mill Street. His grandfather, George Mason, slaveholder and delegate to the United States Constitutional Convention of 1787, notably stated at that convention that, quote, "every master is born a petty tyrant," end quote. Not far from George Mason's Gunston Hall, Gerard's plantation faced opposite the village of Colchester along the Occoquan River in Woodbridge. The sprawling property spanned 500 acres and included a primary residence, a barn and stable, slave quarters, and a large lime kiln. Later advertised as a particularly valuable farm, the productive plantation did not appear without conflict. Mason placed advertisements in local newspapers for runaway slaves as early as 1823. Runaway advertisements revealed general details about enslaved people's appearances and reputations, but also the disagreements and struggles that unfolded in slaveholding households. While it was not uncommon for enslaved men and women to run away, those enslaved on Mason's plantation seemed particularly determined to escape. On October 15, 1822, a man named Bill, around 20 or 25 years of age, left the plantation wearing country cloth, quote unquote, much worn. The description revealed that Bill's hand could not open because of a severe burning he suffered as a child. During the summer of 1828, another man named Will, described as 40 or 45 years of age with 2 missing front teeth, ran also away from Mason's plantation. Bill, however, did not successfully escape the first time, but he reappeared in a second runaway advertisement during the winter of 1840, this time as a 40-year-old man bearing the same burn on one of his hands. Poorly clothed and showing visible signs of physical injury reveals some indication of what life might have been like on Mason's plantation. The fact that Bill risked his life repeatedly to escape Mason's grip provides a glimpse into his tendencies as one of the petty tyrants that his grandfather warned against at the Constitutional Convention. On Mason's plantation, Agnes, like other enslaved people on the property, experienced the hardships and the volatility that came with lifelong bondage on his estate. News sources that originated outside of Prince William County largely read the implications and motives of Agnes's actions as inherently criminal or as a form of malice, which described first-degree murder charges. For instance, the cross-examinations included the standard language that Agnes willfully, deliberately, maliciously, and with malice aforethought killed and murdered her master Gerard Mason by striking him repeated blows on the head with an axe. The justices of the peace for Prince William County decided on the death penalty and offered that under thorough conviction that she committed the murder willful and premeditated while he was in bed and the strong presumption of sleep. But over 70 citizens of Prince William County signed petitions that argued that the extreme penalty of the law should not be inflicted upon the Negro woman Agnes under sentence of death. Instead, they regarded pardon and sale to another plantation as a more appropriate sentence. It was not uncommon for locals to weigh in on cases ranging from minor disputes to widely publicized cases involving slave resistance. Local citizens, again, introduced an alternative set of guiding mores to contextualize the case and Agnes's circumstances more specifically. Following the trial proceedings, witnesses believed Agnes to be 5 weeks pregnant and quote-unquote visibly swollen. The court postponed the scheduled execution in anticipation for the further development of her pregnancy. The execution of a pregnant woman raised important moral questions about hanging an enslaved woman with her unborn child, but most likely the hesitation pointed to economic reasons for assessing the total value accrued as a result of the loss of 2 lives. In Virginia, reproductive considerations may or may not forestall the execution of a pregnant woman, but in this case, the possibility convinced justices to postpone execution. G.W. Clifford, the jailer of Prince William County, wrote a letter stating that Agnes was, quote, very much swollen all the winter and spring, and Dr. Thornton, who examined her, says it is very natural that she should have come to the conclusion that she was pregnant. Indeed, it was the opinion of all who saw her at the time, but now the swelling has left her. It is evident she is not in that situation, end quote. Agnes could very well have been pregnant, particularly given the noticeable weight gain observed by witnesses, but after waiting a few months to see if she advanced in pregnancy, the court concluded the absence of any visible signs of a child and proceeded with execution. Pregnancy was particularly difficult to detect and sustain through the arduous labor demands required of enslaved women. Hard physical labor and emotional and mental duress could stave off a woman's menses or trigger miscarriage. Many accounts in the transcript suggest that she lied about her pregnancy, but those who confirmed her visibly swollen belly might also support circumspection of involuntary or voluntary abortion. The debate concerning whether or not Agnes carried a child underscored the manner in which the courts accounted for the gendered and economic dimensions that came with the reproductive condition of enslaved women defendants. Contestations about Agnes's body not only circulated in letters debating her pregnancy, but also appeared in deliberations about what precisely led to the conflict between Agnes and Mason. Publications that reported the details of the death of Gerard Mason left out critical components of Agnes's cross-examinations, underscoring the gendered assumptions about Black women's criminality and culpability in the antebellum South. Several witness accounts, however, explained that, quote, the deceased wanted to handle her and she would not submit to it, end quote. Testimony placed the spotlight on Mason's behavior and reputation in ways that contextualized the sexual terror that galvanized enslaved women's murders of white Southerners. In response, Mason grabbed for his gun and threatened to kill her, and she in turn reached for the gun and put it away. Mason demanded that Agnes get the axe and start a fire, and Agnes reportedly claimed that the axe appeared too dull for use and showed it to him. A fight ensued, and Agnes killed him with the axe, and he ended up unconscious on his bed. Another account offered that after the gun incident, Mason sent Agnes to cut wood, and he told her she took too long. In response, Agnes informed him that she couldn't sharpen the axe herself in order to chop the wood. The cross-examiner stated that, quote, he wanted to turn up her clothes and take privilege with her. She told him she was too old for that now. And he grabbed the axe and threatened to kill her. She snatched the axe and struck him with it, and he fell on the bed. The legal argument against Agnes focused on efforts to prove that she killed Mason under premeditated circumstances, and news reporters framed her disclosure of Mason's sexual violence as evidence of the premeditated nature of the act, rather than believing Agnes might have defended her life. County locals, however, understood the power dynamics on Mason's homestead firsthand and proposed a revision to the sentence. The petition of local county citizens deepens our understanding of Mason's death in Commonwealth v. Agnes. Petitioners contributed layers of complexity to debates about the sentencing of those charged with crimes, often having no direct relationship to the person they defended, as was the case with those who defended Agnes. Two signatories of the petition submitted by the citizens of Prince William County, W.H. Duvall and Hugh Hamill, appeared in the petition. Although news reporters and justices obfuscated Agnes's testimony, the petition reveals the insights of those with closer proximity to what life looked like on Mason's plantation. Just 4 years earlier, in Commonwealth v. Gerard Mason, Duvall offered testimony in a trial that brought Mason before the court on murder charges. This case involved the murder of an enslaved woman named Katie. Witnesses testified that Gerard Mason notoriously demonstrated a penchant for sadistic violence against enslaved women. William Johnson, a witness in the case, testified that he watched Mason knock 2 black children out of the way as he stormed, quote, apparently in a violent rage into Katie's living quarters. Johnson stated that Mason went into the cabin where he made a great noise as if thumping or knocking people about. Returning at about 11 o'clock to unload wood, Johnson, quote, saw Negro Katie lying in the yard at the quarters. She seemed to be in great pain, as if from a beating, just breathing, just talking, not able to turn about, end quote. James Foster recalled that in the fall of the year before, he saw Gerard Mason, quote, stomp Katie in his yard at his dwelling, end quote. Within the past 2 months of the court proceedings, William Bates saw that, quote, Katie was unable to walk about and has continued so ever since, and stated further that he saw her crawling about her cabin and when crawling would sometimes fall. The violence he committed against Katie's already disabled body did not stop. Henry Duvall testified that he went to Mason to sell wood and saw Mason, quote, beat Katie with a large stick at the home, drove her back to the field, pursued and beat her a second time, knocked her down, and left her lying on the ground, end quote. Every person who witnessed this violence recalled the manner in which she always remained lying on the ground. The imagery of Katie is a snapshot of how Mason expressed power through sadistic violence. He added that just days after, he saw Katie get another beating from Mason, in which he seemed to strike with anything he could get a hold of. As they conducted daily business transactions with Mason, witnesses viewed firsthand the terror he inflicted on Katie. On October 23rd of 1845, Gerard Mason killed Katie and buried her on his property. The court initiated an inquest of Katie's buried body 6 days later to uncover the details of her death. The examination of the coroner and the observations of the jury indicated that Mason, quote, being moved and seduced by the instigation of the devil a short time before the death of his Negro woman slave Katie, with force, and arms at a cabin, in and upon the aforesaid slave, made a voluntary assault. They stated further that Mason, then and there with some instrument, violently struck and cut and gave the said slave several severe wounds. These wounds, located on the back and lower part of the head, 1.5 inches cutting into and taking off part of the skull, fatally wounded her already battered body. Mason spent a brief period of time in jail for the duration of the trial, but justices exonerated him. Locals who testified against Mason in the case involving Katie reappeared to submit a petition in favor of Agnes's deportation instead of execution. The signers of the petition, through their daily interactions with Mason, learned firsthand the incredible degree of violence he inflicted upon enslaved women he legally owned. Men like Mason were supposed to embody the virtues of Southern white male honor and paternalism, but life within the plantation household also served as sites of merciless violence. Southern honor did not preclude the murder of enslaved people, but the excessive and recurring violence on display on Mason's plantation offended local sensibilities. Historians show that Southern honor and the character and reputation of men like Mason required affirmation from the public. Thus, the petition did not protest slavery, but comprised a collection of grievances that spoke to Mason's offensive behavior and violation of social codes of conduct. Even as locals expressed their dissent, Mason's deadly transgressions receded as Agnes emerged from a trial, a murderer. Crime and fatal punishment for enslaved women involved execution practices woven into the legal system, as well as the violent discipline ex juris of the courts within the private and legally protected spaces of white households. Agnes reacted to Mason's threats to kill her by hitting his head with an axe, while Katie could barely physically defend herself as a result of the destruction he inflicted on her body. Agnes received the death penalty at the public gallows, and Mason executed Katie's death sentence at his home. The legal proceedings unsurprisingly demonstrate that the racial and gendered violence experienced by these women did not play a role in the jurisprudence exercised by the justices involved. The petitions of locals at various points during the trials momentarily disrupted the conversation in their efforts to intervene in the future of these women. But ultimately, the legal value of whiteness outweighed the scales of human justice. The resistance and deaths of enslaved women invoke meanings of tragedy and retribution in ways that underscore alternative ideas of justice. This view of justice also provides an important perspective for how we might understand the possibilities of clemency in Virginia. The records mined for this study do not always yield specific articulations of enslaved women's ideas in the ways that the records reveal the ideas of prominent political thinkers of their time. But the actions of enslaved women and girls, whether they appear in physical, chemical, corporeal, violent, or secretive expressions, tell us something about the intellectual and emotional work that enslaved women performed for themselves and their kin. This history of enslaved women and capital crime in early Virginia not only illuminates their unique experiences and relationship to early legal culture, but inspires important questions about the ongoing connections they forged between race, gender, and the American criminal justice system. It also reframes what constitutes intellectual history and considers the possibilities of how our methodologies might breathe new life towards an intellectual history of enslaved women. The stories of these women offer insights about what early Virginia can tell us about the demands of justice over time, and who plays a role in articulating such demands, even as explicit explanations might fail to appear in the written records, and instead emerge in a set of responses. A question interrogated throughout this study is, what is clemency or justice in a society organized by slavery? In what ways do enslaved women dispute the basis and parameters of justice in the slaveholding South? How did these women contribute to a Black radical tradition? This is a complicated story to tell, but one with which we must grapple. Resistance is not a romantic reality for these women and girls, as they paid dearly for their actions. The experiences of enslaved women and girls offer a window into the range of perspectives on justice that expose the balances of power that appeared from the very beginning. In taking seriously their violent encounters, we might more fully consider slavery, criminal justice, and its reverberations. Thank you.
Oh, wow. It does my heart really good to see that we have a standing holy crowd. Thank you so much for being here. We're now going to open up the floor to questions. So if you have a question, I'm going to pass the mic to you. we'll get the mic to you if you have a question, so please raise your hand.
Hi, Dr. Nunley, that was an incredible talk. And as somebody who works with legal documents on marginalized people from the other side of the world, I'm our Asianist at CFC, some of you know me, Amy Gordonier. I just found it methodologically so like really valuable and beautiful to listen to. And so I wanted to ask you a little bit about methods, since I know we have some history majors and
Yes,
other
please.
researchers in here. Can you talk a little bit maybe about the challenges or things that you keep in mind when you're working with these kind of legal documents that are created by a system in which these women are disempowered by people who have obviously really different motivations? How do you unearth from documents written down by people who have the power of literacy, who have the power of record keeping, the agency of these women? I wonder if you could talk a little more about that specifically.
Absolutely. So these legal documents are being created not with the agency of enslaved women and girls in mind, right? And so these enslaved women and girls oftentimes are not, in most cases, are not going to be literate. They're not going to be able to write down their testimony themselves, right? And even as they're speaking and being deposed, right, there's a power dynamic there, right, and who's deposing them, right? That the Southern society, right, has a hierarchy, right, and they're at the bottom of that hierarchy. So when they're being deposed by attorneys, many of their responses are being tempered by that power dynamic that exists as they're being deposed. And so what I was telling the seminar earlier today is that I never see myself as having a definitive say on what topic I'm writing about. I see myself as always having an ongoing conversation with people who are interested in the same things, right? And much of how I wrote this book was being in conversation with people who, I don't always agree with and, write very different kinds of history. But I think that's the beauty, right, is that, any scholar can look at those sources and arrive at a very different set of ideas. And I think that's the beauty of what we get to do here, in higher education, right, is we get to really think through, okay, what meaning can we extract from these sources? And what are the limits to that meaning, right? And there are definitely limits imposed by the archive, particularly because courts are intimidating spaces, right? So how much of your truth can you really tell? And how much can we really know as thinkers and modern scholars with what we have? And so some of the challenges that would come up would be like, well, I need more, or I need you to tell me more, or do I really want to share this, right? And I actually wrestled with whether or not, I wrestle with giving this talk, I wrestle with the kind of quotes that I use, because it is so horrific, and so in some ways I put it on the page so that other people can engage it as well, and we can have a conversation about what we see happening in these sources. But what's interesting to me is that there are all kinds of books written about the legal history of slavery, and also using these documents to write Virginia histories. But there's maybe, I can count on a couple of fingers how many people actually use these stories that have been sitting in the Library of Virginia for many years, right? And so, if anything, I hope that scholars that come after me or with me will continue to engage these same stories.
Ma'am, when you mentioned that there's usually only two paths. When you mentioned that there's only two paths of both violence, be it deportation or execution, did you find any examples of that women escaping these and finding some third avenue, either through like uprising or anything else? There are enslaved women who do escape, and so I do talk about that in the book.
A lot of times we can't know how successful they were in the escape. Sometimes we can tell that they repeatedly escape because we see the advertisements for them running away. But also geography really matters, right? So where do they escape to, right? So Virginia, you can escape to DC or escape to Delaware and then to Pennsylvania, but it can be tricky. And the policing system in Virginia, particularly to track runaways, was probably a little more developed than other parts of the South. But clemency, when we think about clemency today, we think you're free, right? You've been exonerated. But for these women and girls, clemency is you either are sold to the Deep South or you remain on that same plantation. Oftentimes you are sold to the Deep South. And if you're sold to the Deep South and you're buying an enslaved person and you know that they're being sold because they've committed a violent crime, that's going to fundamentally shape that enslaved girl's experience right in the South. And so there are not a lot of expansive avenues for them to go. Thank you for that question.
So I wanted to see if you could go into more detail about the trials themselves. I was actually really surprised that to the degree that there even were, in your stories hearing about the fact that there even were trials and the depositions and so forth. And I wouldn't have expected them to even be given some of those privileges, right? So to the extent that those trials happened, can you talk a little bit more about how they operated relative to, say, other trials at that time?
Yes, so they operated under what Virginia called the courts of oyer and terminer. And so their cases were tried specifically for slave and free black and indigenous offenses, right? So there's a set of laws in Virginia that, there are a set of criminal laws that only apply to black and indigenous people, right? And so there are black codes, right, and codes of behavior. Black people cannot go throughout Virginia without a pass, right, and showing their status as enslaved or showing that they have permission to roam around. They can't be out after certain hours, right? They can't own a gun. They can't, so there's lots of different things. In DC, you can't fly a kite. Apparently, that's very transgressive. And so with that, they're tried under a separate court, right? But they're not tried by a jury of peers, right? They're tried by a jury of locals, many of which are going to be slaveholders and some are not. But that process, right, has often been used as an argument about Virginia being concerned about justice, right? This idea that the early legal system cares about justice, and you can tell that they do because they're given due process, right? But if due process doesn't look like due process the ways that white Virginians can access due process, then what is this, right? And so it's a very different set of considerations. Also, these issues are interesting because they're tied to the economy of slavery. So in Virginia, when an enslaved person was executed, the slaveholder was compensated by the state, right? And so either way, if an enslaved person is given clemency and then sold to the Deep South, they're going to get paid, right? And if they are executed, they're still going to get paid. Right, and so what does that mean, right, for sort of the legal commitments of the state of Virginia? It's very, very interesting, right?
Hi, Dr. Nunley. First off, thank you so much for being here.
Thank you for being here.
It's an honor to be able to listen to you. In the cases of Nellie, I heard you bring up a lot of paternalism and paternalist ethos and ethics. I was really interested to hear more about that concept and maybe how we see that concept maybe in today's world and today's court. So thank you.
That's a great question. Well, I'll speak to the case of Nellie, right? And so one of the things that is interesting is, like I said, when you think about clemency, you think, okay, you're completely free of, of being responsible for this crime, but that's not the case, right? And so clemency becomes this gesture for Virginians who are lawmakers to be able to say, we know that what happened to this person is wrong, but we still got to make sure we get compensated and get this money for, this person because this is a really right, important source of property, right, for the slave owner. And so it's really captures sort of the contradictions of sort of what the nation, what places like Virginia aspire to be versus what the reality is, right? There are lots of people who understand that slavery is a problem, right, and don't necessarily agree with its sort of the persistence of slavery, but yet they're still wrestling, okay, so what do we do, right? And so paternalism becomes a way to say, well, they're treated well, they're fed, they're clothed, right? They're granted moderation, so we didn't immediately kill them, you know, but we sent them to the Deep South, and so it could have been worse, right? But from the perspective of enslaved women and girls, which is what I sort of emphasize, right? That might mean a lot of different things to an enslaved woman, right? And a girl being sent to, you know, along the Mississippi. And some might prefer death, right, over that, right? Or some might prefer being sold. Either way, right, is that justice, right? And is that all that justice can encompass in that historical moment, right? And these are things that both lawmakers and residents of Virginia are wrestling with. And what I think is really fascinating about this time period is the degree to which locals use the petitioning power to say something wrong happened here, right? And these could be slaveholders, these could be people who are not slaveholders, who are just neighbors, and like, this right here is not good, right? And so it really sort of complicates what we think is happening in the South, right? You might assume that if an enslaved woman is accused of a crime, then they're immediately going to be punished. But I think the petition of locals, right, wrestling with this idea of moderation, wrestling with the stain of slavery, is kind of how paternalism manifests itself.
So first of all, thank you for humanizing these women. So as I was sitting here, I was wondering, how do these histories perhaps shape and inform, you know, how women, or Black women particularly, and I'm thinking also Black children, in our present criminal justice system? Because I was listening particularly about how Black children were sentenced, right? And even in terms of their bodies, right? How those were thought about. So I was like thinking about how does, you know, that history inform like some of our present, you know, in terms of how Blacks or Black women and children are treated in our criminal justice system.
I'm really glad that you asked that question. So I wrote this book during the pandemic, you know, when the George Floyd protests were happening, and I was looking at I was looking at sort of all of these images of young people protesting, everybody sort of kind of coming together and creating this mass movement, and I couldn't help but think, right, they're protesting because there's something insufficient about the legal scaffolding of our current moment, right? There's something insufficient about the kind of justice that those protesters are asking for, right? There's something that they're trying to locate in our system, and they can't get it, they can't access it. And this is why they're protesting, right? Because they can't quite get justice, right? And I kept thinking, like, how long has this been going on, right? How long have people who don't have access, right, to justice been expanding its scope and its reach? And I've been thinking about how Black women and the folks who are trying to improve this democracy have challenged it over time, over centuries, not because they had full access to it, but because they were trying to expand its reach, right? And so I see these enslaved women and girls doing a kind of intellectual work of being able to say, I'm entangled in this system that won't allow me, right, to protect my person, right, to be free, right, that there is an economy of right and wrong that are central to our values that are not being realized or expressed in this specific legal system. And I find something similar happening today, right? You know, if you think about the increasing encroachment upon reproductive rights, right? There's a number of things that you can kind of see that are under attack, and you think, you feel hopeless, right? But it's the protests, it's the marching, you know, it's the spreading awareness, it's the grassroots organizing that helps the country realize its egalitarian ideals in a more fuller, right, way. And so that moment kind of inspired the argument for this book, you know, that when they are cornered to the point where they're like, this, I can no longer be terrorized, right? And I'm acting upon this, right? And consciously or subconsciously, whatever it may be, right? This is the only recourse they can find, right? And what does that tell us? What does that convey to us? It conveys us that paternalism is insufficient, right?
Thank you very much for these wonderful comments and just to making that story so complicated. And I would like to return to the question of the petitions.
Yes.
Right. And what I found really interesting in the presentation is that you have these moments in which the community clearly recognizes that something is wrong. And I was wondering if you could speak a little bit more to when those petitions emerge. Do you see them only in cases when girls and women are accused of capital murder, or whether there are other contexts, legal contexts, when we see them? And perhaps if you have the documents or just the sources for that, how are these petitions organized? I mean, so who actually starts them? Who are they part of, let's say, you know, the anti-slavery movement, or are they part of a bigger picture, or are they very, very local?
They're very local, right? And so it's literally the neighbor going down to the neighbor's house down the street saying, like, I don't like how this happened. I don't like how this unfolded, right? And it's particularly after a sentence has been announced. And oftentimes, actually, people gather it around. I mean, this is one thing that I like about the South, right? Not particularly in this context, but in general, right? Is that when something is happening, everybody's showing up, you know, to see what's going on at the courthouse, right? A lot of these neighbors would have sat during these court sessions to listen in on these cases and how they were being decided, and felt like their voices were important, right? And felt like they needed to weigh in, and would assemble, write a letter saying to the government that we do not believe that this sentence, right, is an appropriate sentence for this person. And then it would be, you know, maybe a dozen up to, 100 petitioners, neighbors in the county who are signing the petition. And then, right, from there, the governor of Virginia would decide whether or not to grant clemency. And they weren't always decided in favor of clemency, right? And what I say in the book is that there's no real prescription, right? You know how you have sentencing guidelines today? There's no sentencing guidelines. It's really like, how does Governor Wise feel today? Is he feeling generous, or is he feeling like, okay, I just need this out of the way, right? And so there's no prescriptive guidelines as to whether or not those petitions are going to ensure that an enslaved woman doesn't end up on the gallows. And then there are other contexts of petitioning, whether it's a property dispute, right, a debt owed, right, or disputes about the paternity of a child, right, so it can get kind of messy in the courts, and petitioning applies in all sorts of contexts. Mm-hmm.
Thank you so much, first of all. And I just have a question about the case of Agnes and
Yes,
Gerard.
yes.
So was Agnes given clemency? And then, because I know you mentioned her emerging back to trial.
Mm-hmm.
And was that common, other than these cases, for slaves to be given clemency and then be brought back or sold to other places after?
So with Agnes, so once you are charged with a crime, you remain in jail in Virginia. Those jails are probably next to the courthouse or not far from it. So you remain in jail until your sentence. They executed whatever sentence they were going to give you. With Agnes, after she was sentenced, Prince William County residents put up a petition to say, like, you don't know this guy, Gerard Mason, like, let this girl go. And then they didn't, right? And it goes back to my point, right, that you can have a compelling case, right? Gerard Mason was just on trial right, for murdering Katie 4 years ago. So he has not only a clear reputation, but he's in the legal record. And that wasn't compelling enough, right, where it was compelling enough for, Ellen and Elias, right? And so there really is no prescriptive guidelines as to, okay, if they meet this criteria, then we might lean more towards, clemency. So it really just kind of varied. But Agnes, she ended up on the gallows. And I actually came across this story because I was working for the Prince William County Historic Preservation Division as a graduate student, and we were restoring the jail that she was confined in. And they brought me in to say, so how do we tell this story? This is a family-friendly stop, along Prince William County's historic tourism trail, right? And it's wild because, the room that she was jailed in gave her a direct view of the gallows, and then the courthouse was right next to it, right? And so every day for months and months and months, she just stared at the gallows. That was her only view, right? And so that space invites you to think about what that might have looked like and felt like for her.
Thank you, Dr. Nunley, over here, right in front of you.
Oh, okay. I was
sorry.
like, where's this voice?
I know, right? Thank you. This is a piece of scholarship I've never encountered before, so thank you for bringing this to the College of Charleston. I want to ask, I know your work here is focused on the early Virginia period. Do we see consistent patterns in the actions of Black women and girls against their owners throughout time in this, as we get closer to the Civil War, as we get closer to legal freedom? And if so, do we see any changes in response of the Black codes or the law governing slaves in that time to respond to any changes in violence or changes in behavior?
Absolutely. By the time we get closer to the Civil War, you still see consistently, not always, right, but you still see a consistent pattern of resistance. And what this tells us is that enslaved people don't just accept, right, the condition of bondage, right? They contest it, whether it be in a really small, sort of passive-aggressive way or whether it be a really overt, right, way. I'd say particularly during the American Civil War, that's when they really are like, something is happening. And I'd say this in every military conflict, right? The American Revolution, the War of 1812, they're like, this is it. This is our time. Like, light this joint on fire. Like, burn the crops, right? And like, we're leaving, right? And actually, the last chapter of this book is all about that. It's all about insurgency, right? And like, folks are like, we're just going to put this poison here and see what happens, and then see what we're going to do next, right? So they're plotting because they feel the rupture of the nation. The nation is falling apart, right? And they have always used opportunities, particularly of military conflict, to act on their desires for freedom. And, in the first book, I talk a lot about this, right? That sometimes envisioning freedom, these women never act on it, right? It's just every day, right, performing the same drudgery, the same work, but like that doesn't stop them from thinking about liberty. That doesn't stop them from plotting something. And they may not ever act on it, right? But, those liberty dreams are still there.
Thank you so much for your talk, and it made me think about Callie Gross writing about the politics of protection. And then it started making me think, maybe the politics of protection isn't even the best way to describe what's going on, because if, with the politics of protection, you have people like Marissa Alexander, this Black woman who fires a warning shot because her estranged husband is breaking a restraining order and coming into her home and threatening her.
Right.
And then she gets sentenced to 20 years in prison for this, right?
Yes.
And so you see the legal system not protecting Black women, and yet when they protect themselves, they get sent to prison.
Yeah.
And the idea of protection, to me, in some ways, reminds me of the kind of paternalism of a sort. So, but I think that a true liberation isn't relying on paternalism, which, as you point out, has many limitations. So I'm wondering if you have thought about what is a better framing for perhaps what Gross is calling the politics of protection, given how, to me, it does sound a little bit like, even though it's a little different, from this kind of paternalism of the antebellum South.
And Kelly Gross actually blurbs the back of the book, which I'm really grateful, especially during this time. I would say that I really don't engage with the politics of protection. I really sort of think about this. I think about this more organically as about ideas, about right and wrong, right? And so when you don't have the language of rights, when you don't have the language of protection, what are you basing what you're asking for on, right? And not necessarily asking for, like, how can you get this person to stop bothering you, right? Like, and like, how can there be laws that hold them accountable for their actions, not because you want protection, but you're just trying to live. And I think that these women, I kind of see them as really sort of developing their own epistemologies or ethics around justice and about right and wrong. And it looks different than the legal system that governs their lives, not protects them, but governs their lives, right? Polices their behavior. And in that way, I see them sort of doing intellectual work rather than sort of thinking about sort of entitlements to the legal system, right? Entitlements to protection. I think they know well enough that, they don't have those rights, right? So how do you then articulate, express, right, that this is wrong, right? And I think what's interesting about this too is, right, in the law, to give you an example, right, enslaved women are not rapeable, right? And so there is no legal recourse for raping an enslaved woman. But that's wrong, right? And so for centuries, Black women and girls have been saying that's wrong, right? And building a social economy of right and wrong that that they now are sort of, now we see codified in law. But what did it take to get there? What kinds of ideas were people developing in order to expand our idea about justice and what right and wrong looks like in our legal system? But also just ideas that we build over time that change, right? Change with society, change with new generations. And how do we make space for that? And I think that with this work, I try to think about that, both in the contemporary context, right? Like, how do we make space for things that were, not allowable or not accessible 50 years ago, but we're demanding, right? We're demanding right now, and quite frankly, people have been demanding for 50 years, right? And so just kind of thinking through that organic process is messy, right? Because it's not clear-cut. These women are not literate, right? They can't sort of give me their treatise on justice, right? I have to kind of look for what's happening in their actions.
This is going to be our final question, and then we are going to bring forward Dr. Jason Coy, who is the chair of the History Department, to provide us with some closing remarks.
So thank you so much. This was such a wonderful talk. My question was prompted by what you were asking about, which is, I think in 19th century legal studies recently, there have been a kind of spate of books about the legal system as a kind of piecemeal pathway to emancipation. I'm thinking about Martha Jones or Adriana Chiar or Alejandro de la Fuente and Ariela Gross. And what I often take from those studies is a kind of shifting away from emancipation as a kind of revolutionary and incredibly violent process. And so your book strikes me as doing something really different from that, and I was wondering if you might want to, I'd just be curious what you think about that and that move that you're making.
Yeah, I think that, emancipation is one moment along the continuum of a Black liberation struggle, right? Folks are still trying to be free, right? So there's a lot, and I'm trained in Black studies as well, right? And so, we were always trained to understand that there's a longer Black liberation struggle, right? And that emancipation is a really important moment to signpost in that struggle, but it doesn't define, right? It's not a definitive moment in that struggle in the ways that we traditionally teach it. And so I see that, and this is why I use the Thalia Glimpf quote in the beginning, right? She says that these are knowledge brokers that have developed a politics of anti-slavery by being enslaved, right? Enslaved people don't want to become free because abolitionists, put pressure on, the Union, right? Enslaved people don't want to be free because the Republicans became radical, right? Right? Or, Abraham Lincoln decided that it was time now to sign an Emancipation Proclamation. Black people have always wanted to be free since they landed here. And so what do they do with those ideas of freedom? And they manifest themselves in different ways. And so for some, like Martha Jones, right, talking about citizenship and the legal scaffolding of the nation and doing sort of the legal work of challenging, right, their exclusion from citizenship and freedom through petitioning the courts, right? Ariela Gross also talks about, right, what it means to petition the courts. And for me, I'm more like, and I remember saying this to a reviewer, right? Because they were like, talk about what's happening in the courts. And I'm like, this is not about the courts. This is about the kitchen. This is about the cabin. This is about households, right? Because this is where it goes down, right? And this is also where, Black women and girls formulate their ideas about right and wrong, right? By the time they get to the courts, the deed has been done, right? Like by the time they get to the courts, it's gotten out of control, right? And so the courts, right, become an endpoint, where they meet their fate, right? And so in a lot of ways, if you're thinking about the perspective of the enslaved and children, right, it's the courts don't seem as much of a viable avenue from which to begin to sort of make a liberation claim. And so in that sense, you're right, I do depart from that work. And at the Threshold of Liberty, I talk about, right, how Black people make claims to the court for freedom, right? They go to the court, they successfully petition for their freedom. But also I talk about the courts as a space in which they're pulled in and criminalized and, right, brought in for violating, for flying a kite in DC, right? And so the court is very, is a very unusual space, and it's also a complicated space that can do a lot of different things in the life of a Black person.
Thank you.
Hi, everyone. I'm Jason Coy. I'm the chair of the History Department. Just a few quick thanks. Thanks a lot for coming. Thanks for all the great questions. Thanks to our organizers, Professors Eves, Jones, and Dingley, way back there. Thanks to all of our co-sponsors. And most of all, thank you, Professor Nunley, for this fabulous paper. I'm teaching the senior seminar or capstone this semester, and I can't wait to talk to my students about it tomorrow, about how powerful history can be. I mean, I think you did a wonderful job of just weaving together really harrowing tales of violence and oppression and injustice, but then with a larger purpose to also show the power of resistance and survival and people really trying to assert their humanity, within a terrible, terrible situation. So thank you very much for coming to our campus and sharing your research.
Yeah.
Thank you, everyone.
I've been intending to say this for the last 3 times I had the mic and keep forgetting. But please step by this table in my far left, your right, to purchase a copy of Dr. Nunley's first book, At the Threshold of Liberty. Our campus bookstore has provided copies for you to purchase if you would like, and perhaps Dr. Nunley would indulge us with some signatures if people would like for her to sign their copies. So now, thank you so much for coming.